This case starts fast, and it gets messy even faster. What you're about to watch is a courtroom moment that perfectly captures the chaos that can happen when law enforcement authority, citizen behavior, and unclear communication collide. We have a defendant who is not the murder suspect, officers executing a capital murder warrant, and a confrontation that turns physical within seconds. The stakes? Up to 6 months in jail and a $2,000 fine, all stemming from a charge of interference with public duties. Here's the key tension to keep in mind as you watch. Was this person actually interfering or simply trying to access their own residence while police activity unfolded? Because legally, that distinction matters a lot. Police absolutely have authority to control a scene during a felony stop, especially one involving a capital murder suspect. But that authority still has limits, and those limits depend on clarity of commands, proximity to the suspect, and actual obstruction. Pay close attention to how the facts are described, how often they shift, and how uncertain even the prosecution sounds as the judge starts asking basic follow-up questions. This case isn't just about what happened. It's about whether the state can clearly explain why it happened. And when that explanation starts breaking down, that's when cases fall apart. Stay locked in because the judge notices everything.
Will be used against you, sir.
Yes, sir.
On March 28, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle, and began walking to the residence where the murder suspect was. The officer's supervisor ordered the defendant to stop and stay right there. The defendant refused.
This right here is the emotional flashpoint of the entire case. According to the state, the defendant ignores repeated commands and continues walking toward the residence. And that's when officers physically intervene. From a legal standpoint, this is where probable cause either solidifies or collapses. Interference with public duties requires more than just being present. It requires an actual hindrance to officers doing their job. But listen closely to what's missing. There's no clear explanation of how this person endangered the felony stop, no indication they were armed, and no confirmation they even knew what was happening. The defendant blurts out, "I live there," which introduces a critical wrinkle, because access to your own home isn't automatically illegal, even during police activity, unless specific legal boundaries are clearly communicated. This is also where contradictions start creeping in. Was the murder suspect actually inside the residence? Or nearby? Or already detained? Because the answer to that question determines whether the defendant's movement posed a real threat or just an inconvenience. So let me ask you, if this were your home and officers were outside, would you stop immediately or ask questions first? And more importantly, should confusion alone justify force?
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there.
Stop.
Oh, sorry, sir.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant. Ordered him to stop. He refused to stop going towards the residence, Your Honor.
Did it serve the warrant? What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was service was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence, and that's been this incident.
Read it again, if you don't mind.
Yes, Your Honor. On March 28, 2025, the law enforcement officer and Squad 5 of the Houston Police Department's Gang Division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, The defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant was once again ignored the officers. The law enforcement officer grabbed the defendant and made him bounce and the ground.
Okay, so
This
now,
is the moment the entire case starts to unravel and the judge sees it in real time. The prosecution initially claims officers were serving a warrant on a suspect at the residence. But then the details change. Now the suspect is allegedly in a truck at a nearby location, not even inside the home. And that inconsistency is devastating because probable cause must be clear, specific, and consistent. When the judge points out that the suspect may not have been in the residence at all, it raises a massive legal problem. Why was this defendant's movement toward the house treated as a threat in the first place? If the target of the warrant wasn't there, then the justification for escalating force becomes extremely weak. This is why judges slow things down and ask uncomfortable questions. They're not just listening, they're measuring credibility. And once the court senses uncertainty, the burden shifts back to the state to clean it up. Spoiler alert, that doesn't happen here. So ask yourself, is this a case of defiance or a case built on assumptions that didn't hold up under scrutiny?
now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what, so I was originally reading the summary, and I'm going straight from the agenda now, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that that the suspect, that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor. I have nothing for that.
I find no probable cause in your case. Just be careful, man. When you get into a pissing match with
I understand.
who's going to win,
They are. I understand.
no.
Yes,
At
sir.
the end of the day, this case is a textbook example of why facts matter more than force. The charge was interference with public duties, but the court struggled to establish the most basic elements. Where the suspect actually was, whether the defendant truly obstructed police action, and whether the commands given were tied to a legitimate, immediate threat. Without clear answers, probable cause simply doesn't survive judicial review. The judge's warning says it all. Yes, arguing with police on the street is rarely a winning move. But in court, the state still has to prove its case. And here, the inconsistencies spoke louder than the allegations. The broader takeaway is powerful. Lawful authority doesn't excuse unclear execution, and proximity alone doesn't equal guilt. Now I want to hear from you. Do you think this arrest was justified, or did the officers overreach? Drop your thoughts in the comments below. And if you found this case as shocking as we did, make sure to hit that like button, share this breakdown, and subscribe for more jaw-dropping courtroom analysis. You won't want to miss what's next. Fire balance scale.